All right, well, welcome everyone. Thank you so much for joining us for Estate Planning, what every young person should know. My name is Amanda West. I am a breast cancer survivor. I was diagnosed back in my 30s, and unfortunately, I didn't know about YSS. And I found out about it later after my treatments. And I was really thankful that I had the privilege to go down to LA actually and go to the event in person before COVID. But I am so happy that they're doing this virtual for all of you today. And before I get the show started and introduce Monica, I just want to go through a few logistics for all of you today. Number one, this is being recorded and it will be on demand for 30 days after this event. And number two, if there's any questions, please just enter those into the chat and I will get to them at the end with Monica. And please, when you're asking questions, please try to make these general versus personal consultation or legal advice. So without further ado, would like to introduce Monica Bryant. She is a co-founder and COO of Triage Cancer. So Monica, I'll turn it over to you.
Thank you so much. If the facilitators could allow me to share my screen, that would be great. Today, we are here to talk a little bit about estate planning. And I have to tell you that this is one of my most favorite and least favorite all at the same time presentations to give. It can be incredibly challenging to talk about estate planning, yet equally empowering. So hopefully by the end of the session today, you all will feel similarly. So before we get started, I just want to tell you a little bit about Triage Cancer. So we are a national nonprofit that provides education on the practical and legal issues that arise after a cancer diagnosis. And that really can run the gamut from health insurance to employment rights to disability insurance, and of course, estate planning. And we provide that education in a couple of different ways, including live events, as well as a plethora of resources that are available for free on our website. And I'm going to point you to some of those resources today. But I just want to remind you that Triage Cancer can be a resource for you in addition to YSC even after today. So with that out of the way, when we talk about estate planning at its core, we're talking about the process of creating a plan that ensures that your wishes about the distribution of your property, your wishes around your healthcare, and caring for your loved ones are carried out in your absence. Now, what's hard to talk about estate planning is around our mortality. No one really wants to think about our mortality. But the fact of the matter is, there is one thing that is going to be true for each and every one of us. And that is, at some point, we are going to die. And certainly that can be emotional and even harder after a cancer diagnosis. But what I think is so fantastic is that in a situation where so much control is taken away from someone after a cancer diagnosis, estate planning is an opportunity to regain some of that control. So who needs an estate plan? Well, certainly Beyonce and Jay-Z, who have the collective net worth of, I don't know, a small country, need an estate plan. I would argue this lovely lady who is over 100 years old could probably benefit from an estate plan. Certainly this family with small children needs an estate plan. And I would argue that these two young ladies who may not even be 18 yet could still benefit from creating an estate plan, even if it isn't legally enforceable. There is value in documenting your wishes no matter what. So if you are joining today because you are feeling like you are behind the game with respect to estate planning, please know that you're not alone. So these are three incredibly famous human beings, all of whom died without an estate plan. And so it is definitely something that people don't always realize, that close to 70% of Americans, regardless of age or cancer diagnosis, don't even have a will, which is the most basic estate planning document. So I hope we can like eliminate any potential guilt that is sitting around you around not estate planning. And I certainly, high five you for taking this step even. So why do we plan our estate? Well, we've talked about documenting your wishes, but I think that there are also some really practical reasons around finances, peace of mind, making sure that you don't lose the things you've worked to acquire. But at the end of the day, I think estate planning is one of the most loving things that we all can do for our families. And that's because at a time when our families, loved ones, friends are grieving, they won't also have to spend energy navigating these practical pieces because we failed to plan. It's a very loving thing to do in my mind. Now, if none of those things resonate with you, how about this one? I'm a very type A human being, and I look at estate planning as my opportunity to still have control over things even after I've died. So regardless of what resonates with you as a reason to estate plan, hopefully one of these reasons does and gives you the push that you need to move forward. Now, if you are starting at square one and you've never thought about estate planning or created any estate planning documents, these are some big picture questions to start with. And sometimes they take some thoughts to really come up with an answer. Again, if you are starting from scratch and feeling overwhelmed, maybe pull out a journal and see if journaling about these particular questions helps you get to an answer. When you are estate planning, you need to understand what your property is. So what do you actually own? So certainly if you own any real property like a home or land, those are going to be things that you want to include in an estate plan. And any personal property. So a wedding ring, a antique camera, a baseball card collection, anything that sort of can be picked up and moved would be considered personal property and could be included in an estate plan. But then there are all sorts of things that you may own that aren't actually tangible, like bank accounts or retirement accounts, or even a life insurance policy, perhaps. Once you've collected the information around what you own, it can be helpful sometimes to figure out what it's worth. And there are kind of two different pieces of this puzzle. The first is about the actual monetary value of something. So if you were to get it appraised, how much would it be worth? But please don't forget the sentimental value. There are things that many of us own that if we were to go sell it in the marketplace, we would get very little money for it, but they have great sentimental meaning to us. Those items could be included in an estate plan as well. So once you've decided what you own and how much it's worth, now you need to figure out how you own it. And there are a couple of different ways to own property. So sole or individual ownership means you alone own that thing. You go to a car dealership, you put the money down to pay for all of it. Your name is on the title, you own that car solely. But there are lots of pieces of property that we own in joint ownership. And there are a couple of different ways to own something jointly with someone. So something called a tenancy in common means there are two people that own a 2-unit apartment building. In Chicago, we call them 2 flats. Person A owns the first floor, person B owns the second floor. Person B puts their unit in their will and can will it to whomever they like upon their death. That's a tenancy in common. That's different than a joint ownership with right of survivorship. And this is how many married couples might own a home together. And you might be thinking, why do I need to know this? And the reason is that depending on how you own something, it's going to determine how you deal with it in your estate plan. So if you own something jointly with right of survivorship, you don't actually have a certain percentage of that thing that you would put in your will. Rather, upon your death, the entire ownership just transfers to the other person. Married couple buys jointly with right of survivorship, husband passes away, house goes entirely to wife. And then the third way to own something is by contract. So things like a lease, for example, would determine how you own that thing. Once you've figured out what you own, what it's worth, and how you own it, we can start to narrow in on which documents you might need in an estate plan. And I would argue that every single person over the age of 18 needs 3 of these documents. We're going to go through all of them, but just keep in mind that you might not actually need every single one of these documents. So starting with a will. A will is a fundamental component of any estate plan, and it's one of those things I think everybody should have. It's a legal document where you're going to deal with most of your property and assets and guardianship of minor children. Well, why do I say most of your property? Well, there are some things that you're not going to put in a will. So remember how I said if you own something jointly with right of survivorship, you don't actually have any piece to will because it automatically goes to that second person. You also wouldn't include property where ownership has already been decided, like a life insurance policy or a retirement account. Typically, when you purchase the life insurance policy or open a retirement account, you right then and there name the beneficiary. Who's going to benefit from that life insurance policy? Who's going to get the bulk or the remainder of that retirement policy if you were to pass away? So because you've named it in the document itself or the entity itself, you don't also include it in your will. There are several different types of wills, handwritten wills, fill in the blank wills. You can get a will sort of DIY. There are paid services like LegalZoom where you answer a bunch of questions and then it populates a will for you. There's a free service to create a will called freewill.com. And then there are wills where you go into a lawyer, you tell them your preferences, and the lawyer drafts the will. There's really no right answer into how you create your will, whether you do it yourself or you get it from a lawyer. But keep in mind that the rules around some of these types of wills are going to vary from state to state. And if you're interested in what the rules are in your state, I suggest that you go to triagecancer.org. And under the estate planning resources by topic, we actually have a chart of the rules for every single state on what you need to do to create a valid will. So for example, in some states, a holographic or handwritten will isn't allowed. The reason I talk about sort of that DIY option is that a lot of people will say to me, I don't have money for a lawyer. I'm barely making ends meet. So that's why I didn't create an estate plan. And for simple estates, a DIY version is perfectly acceptable. The times when I suggest maybe someone think about a lawyer is if they have a complicated estate, like property in different states or countries, maybe even, or if they have a really complicated family. So stepchildren, or potentially if you are a non-married same-sex couple, that could also sometimes complicate estate planning. So sometimes in situations, it's helpful to go to an estate planning lawyer, but not necessary. So as I mentioned, it depends on the state in terms of how you actually go about creating the will, but in most states, you have to at least be 18. You have to be of sound mind, which means you know what it is that you are doing when you're creating the will. Generally, you're also going to have to sign it yourself and have it be witnessed. Now, I would say biggest discrepancy state to state in terms of the rules is around the witnessing piece. Sometimes it can be just notarized. Sometimes it can just be 2 witnesses. Sometimes they want a witness and a notary. So really looking to your state's rules is important for that witness piece. When you're creating a will, there are some decisions that you have to make. So who are going to be the beneficiaries of your will? And this is who's going to benefit, who's going to get the things. You can be super general leave everything to my sister. You can be super specific. My Bon Jovi CDs go to my brother, the motorcycle goes to my sister, my clothes go to my kid, or some combination thereof. And so this is really where you get to tailor your wishes. I also want to just remind you that beneficiaries don't necessarily have to be humans. Sometimes people will say to me, I don't really have family, so why would I create an estate plan? It doesn't really matter. Well, in that case, you could actually make the beneficiary an organization like YSC, or an institution like your church or your alma mater, your college. And again, it can be some combination thereof. Certain things go to some people, X amount goes to an institution. Then if you have minor children or other dependents, the will is where you would name your guardians for them. It is preferable to name more than one potential guardian in the event that your first person can't do the job. Never name co-guardians, because that causes all sorts of legal problems, but certainly alternate guardians in the order that you want them to, sort of go down the list is what's helpful. And then finally, you need to name your executor. And this is the person that's really in charge of a whole bunch of things related to your estate. The executor can be a family member, a friend. Some attorneys will do this service for a fee. Some banks will do this service, but it is actually quite a bit of work in some situations. So when you're thinking about potentially picking a guardian, it could be that you have one person who's the guardian of the person, who's going to be responsible for like the day-to-day feeding, clothing, getting them to school. And then the guardian of the estate, which is who's the person that's in charge of the money or the property that maybe was left to the minor. Many times it ends up being the same person, but it doesn't have to be. The other piece around guardians to think through is thinking about, when you pick a guardian, does that person have the same values that you have? What are the pieces that are important to you for that person to manifest? So, and I hate the word characteristics to describe this, but I've yet to come up with a better one. But if having somebody of the same race or ethnicity is important to you, that's a consideration. Politics, religion, geographic location, all of those things are things to take into consideration. Now, with respect to an executor, the reason why sometimes people will pay somebody and rather than asking a friend is that it's a little bit of work. This is the person that literally takes the will and files it in court, handles figuring out where all the assets are, handles the distribution pieces. So it can be a lot to ask of a friend. Another barrier for a lot of people in creating an estate plan is this idea that once I create it, I'm stuck. And what if I change my mind? Wills can be changed as often as you'd like, but the trick with it is that you can't just cross something out and write in the margins to kind of edit it. It actually has to be changed through something called a codicil, which is essentially an amendment to your will that is drafted and executed in the same way your will was. So if your state says no handwritten wills, no handwritten amendments or codicils. Your state says signed and notarized, that's what the codicil has to happen to. So please don't let this fear of, well, what if I change my mind, be the thing to stop you from creating the will. What happens if you don't have a will? Well, you're certainly going to have a more complicated probate. It's going to be more expensive. So that means less money or things to leave to your loved ones. It's going to take longer and you have no choice. The property gets distributed by statute. So every state has rules about how the money gets divvied up or the property or whatever gets divvied up if there is no will. So all control is taken away from you if you don't do your will. So this checklist is created in our checklist to getting organized. It's available on our website, but it basically just sort of shows you the checklist of all the things you need to do when you're creating a will. Now, another estate planning tool is a trust. this is something that not everybody is necessarily going to need, but there are certainly some benefits to creating trusts. I'm not going to spend a ton of time on it today because I want to get to the medical decision-making piece. But if you are thinking about creating a trust, I would just remind you that trusts are not substitutes for wills. There are things that wills do that trusts cannot do. And I would also suggest that you actually find an estate planning attorney that deals in trusts in your area, because with trusts, you are actually giving up ownership of that property and putting the ownership in the trust. So in my mind, this is not something that you would want to necessarily do DIY. So now I want to switch gears a little bit and introduce you to Alice. Alice is a single mother of an 8-year-old son. She's an only child. Parents have passed away. Last month, she moved to Denver with her son and 2 dogs. Alice has metastatic breast cancer, and today she's attending a conference for patients hosted by a cancer organization. After dropping her son off at school, Alice realizes that she forgot her wallet and checkbook at home. Her landlord told her that she needs to pay rent today or he will give up her apartment. She decides to head back to get her wallet before driving to the conference, but before she makes it home, she's in a severe car accident. Alice is unconscious at the scene and is taken to the hospital in an ambulance. Alice doesn't have her wallet, so they don't know who she is. She needs surgery, and her healthcare professionals do not know if she has an advance directive. Her son needs to get picked up from school. Her dogs need to be fed and let out. And oh yeah, she's got to pay rent or she's going to lose her apartment. So Alice sets the stage for the piece of estate planning that is about how to document your wishes before you pass away, but when perhaps you're unable to express those wishes. And the first document is the power of attorney for financial affairs. This is a document where you name an agent, and that agent has the power to conduct certain financial matters for you. There are 2 types of powers of attorney for financial affairs. There's a standing, which means as soon as you sign that document, that agent has the power. Or there's a springing, which means you could sign it today, but it doesn't go into effect unless you become incapacitated in some way. This power of attorney for financial affairs, again, is not a substitute for a will because it ends the moment you pass away. So this would be one of those documents in addition to a will that I think everybody should have. So what can an agent do when you have a power of attorney for financial affairs? They can pay bills for you. They can make deposits or withdrawals from your bank account. They can handle your taxes. They can sign applications for benefits. Like if you were applying to Medicaid or Medicare, they could do that on your behalf. They could manage real estate. They could hire an attorney. They could oversee your insurance or retirement accounts. So if any of you were in my last session around, planning ahead and getting prepared, I talked about if you're feeling overwhelmed by like the day-to-day dealing with insurance companies and your bills, one solution would be to create a power of attorney for financial affairs so that a loved one could do all of those things on your behalf. So what happens if you don't complete a power of attorney for financial affairs and somehow you become incapacitated? Well, then the courts get to decide. And what they would do is actually name a conservator. Conservatorships have become a little bit more well-known, I guess, thanks to Britney Spears. But there are 2 types. So there's a conservator of the person. So that's about dealing with like the health and well-being of somebody. And then there's the conservator of the estate. And that's somebody who would be dealing with the financial pieces. But here's the kicker. Sometimes the court just appoints someone from a pool of people who have said, hey, I'll be a conservator. So you may have somebody you've never even met making these decisions on your behalf if you don't plan ahead. In addition to the power of attorney for financial affairs, we need to think about what we can do to plan ahead to document our wishes around medical care. And this is where we get into the conversation around advance directives. And there are lots of different types of advanced directives, and I'm going to talk about the most popular one today, which is my third document I think everybody should have. Meet Frank. Frank received a call last night that his brother, John, had been in an accident and was unconscious in the hospital. Frank's his only living relative. Although John is breathing on his own, the doctors aren't sure if he will ever wake up, and he will need artificial hydration and nutrition very soon to survive. John does not have an advanced healthcare directive, but Frank remembers hearing John mention once that he would, quote, never want to be in a vegetative state as their father had been years earlier. The doctors want Frank to approve or reject artificial hydration and nutrition. Frank is devastated about the possibility of losing his brother and is racked with guilt at the thought of, quote, pulling the plug. This, Frank, sets up our conversation around the need for an advanced healthcare directive. And the advanced healthcare directive, one of the most popular ones, is sometimes called a living will. This is where you get to actually write down or document your wishes for medical care. So you could be saying you do or you don't want specific treatments. So I absolutely want antibiotics and pain management, but I don't want a blood transfusion, or I don't want to, be using stem cells. You can document where you want to get treatment. So if we're at a certain point and a doctor believes that I'm not going to survive, I want to be sent to hospice because I don't want to have my family's last memory of me be in our home. Or perhaps it's the complete opposite. I want to die at home. And that's something that you can document. It's also a place where you can make some decisions around organ donation or burial wishes. So a living will is your opportunity to write all the things. But here's the thing. Most of us can't come up with every possible scenario. Think about Alice, right? She was going to this conference. She had no idea she was going to end up unconscious. So to protect yourself from the sort of unknown or the things you didn't think about, you could also have a power of attorney for healthcare. And this is where you name an agent to make medical decisions for you. This is called lots of different things: agent, proxy, surrogate, attorney, advocate. But really what it is the person that you're giving authority to make medical decisions for you. Just like with guardians and just like with powers of attorney for financial affairs, you could name alternate agents. You should never name co-agents. There are so many court cases out there because people named two people and those two people disagree. So again, always very helpful to put people in order. Now, anybody can be an agent as long as they are old enough and they're not one of your healthcare providers. And so thinking about the types of decisions that the agent would need to make is helpful sometimes when you're trying to figure out, okay, who can be the agent? Now, for some people, the same person would be your power of attorney for financial affairs and your power of attorney for healthcare. For some people, they would be very opposites. So maybe you want your empathetic, loving, amazing, caring sister to be your power of attorney for healthcare because you know that she would make the same kinds of decisions you would, but she's terrible with money. So instead, you're going to name your, uncle as your power of attorney for financial affairs. One cannot be substituted for the other. Your power of attorney for financial affairs can't make medical decisions for you, and your power of attorney for healthcare can't make financial decisions for you. So that's why you really need the three documents. Now, with advanced healthcare directives, you could have just the living will where you write down your instructions, or you could just name an agent. But what is most protective is to actually have both. And when you have both, that is what most people mean when they refer to an advanced healthcare directive. In addition to your instructions for healthcare, living will, and naming that agent, You can also include resuscitation instructions in this document. There's going to be some information potentially around organ donation. And just like wills, there are rules around how to execute it. Signed, witnessed, 2 witnesses, 1 witnesses. It's all going to depend on the state. So when you're looking to figure out who's going to witness, the witness can't be your agent or related to you, can't be your healthcare provider. Lots of people get stuck on the witnessing piece. If that's a challenge for you, I will let you know. I had my across the street neighbor, who I am friendly-ish with, come over and witness the execution of my estate planning documents. We are by no means best friends, and he's not benefiting from anything in my estate plan, which is why he was a great witness. So sort of thinking about other people in your sphere to witness that don't benefit from your estate is helpful. So just like with financial powers of attorney, if you don't plan ahead, you can have a conservator for medical decisions as well. I also want to just talk a little bit about some of these non-legal wills that are talked a lot about in the cancer community, and these are sometimes called ethical wills or living legacies. These are not a substitute for a legally executed estate plan. Writing down your wishes is great and has lots of value, but make sure that for those 3 pieces at a minimum, the will, the power of attorney for financial affairs, and your advanced healthcare directive are executed in a way so that they are legal in your state. Some bigger picture things to consider about estate planning that aren't necessarily legal in nature. Who needs access to what? So are you the only person that has the code to get into your house? Are you the only signatory on a safety deposit box or a storage unit? Do you have a bank account nobody knows about? These are the kinds of things that are really helpful to share with, at a minimum, the person you've asked to be your executor, so that they don't have to go get a court order to access these things. Additionally, as more and more of us live our lives online, remember that these non-tangible things like our email are property. I know some people, last time I did this in person, someone was like, thank God, like I don't have to deal with my email anymore. I'm dead at this point. But I will tell you, it is helpful to have a plan for someone else to be able to access your email. If you get bills sent to you electronically, email is also the thing that connects us to many online storage systems. So if you have photos on iCloud or music stored in a cloud or documents stored in a cloud, all of those things, you're going to have access to the email. Social media accounts are something else to think about. There are different options depending on the platform. Facebook allows you to make a memorial page. Gmail allows you to name someone who's responsible for your digital afterlife. But just keep in mind or think about all the things that you have that aren't tangible that might be stored electronically that you would want to be preserved. And then I think that when you're thinking around, okay, I've created these plans, now what? It's really helpful to figure out a system for how you're going to store those documents. Certainly things like stocks and bonds and documents around mortgages and passwords and keys are all things that someone else needs to have access to. Some are going to be ones you probably want to keep in like a safe or a safety deposit box. But again, make sure that the right person has access to it. Now, your will and your advanced healthcare directive and your power of attorney for financial affairs should not be kept under lock and key. It should not be a secret that you have these documents. These documents should be shared at a minimum with your executor, with any guardians that are part of the discussion, with your power of attorney for financial affairs, and with your power of attorney for healthcare. One way to do this is to actually store the documents on the cloud. So I use Google Drive. I have a folder in my Google Drive that has my family's estate planning documents, and a link is shared with all of the relevant people. And what's great about that is as I update documents, I only have one place where I need to take a document down and put a new one up. It's also fantastic because regardless of where, let's say, my agent is in the world, she has access to that document. As long as she's got a Wi-Fi signal, she can access that document. For people who may be closer to end of life, sometimes they'll want to post a document like on their bedside or on their refrigerator so that any first responders might see it. There are also some paid services like Dropbox or Master Lock Vault that you can use if you're particularly concerned about the cloud. I also think if you do create an advanced healthcare directive, it's helpful to document that in a way that is going to be with you most of the time. I know most people don't leave home without their watch or their phone, and so we can use technology where, iPhone, and I'm sure Android has the same thing, in your emergency contacts, there's a note section, and you can actually list that you have an advanced healthcare directive. And first responders are trained to look for this information. So when you think about Alice, who forgot her wallet and doesn't have an ID, as long as she had her phone on her, they would have that information. And then the last thing I want to talk about today is funeral planning and planning ahead. This is tricky. Funerals are very expensive, and most people are really surprised how expensive they can be. And we've heard that loved ones have challenges in planning funerals. One example is a husband who lost his young wife, and he was in a really bad financial situation. And we were talking, and I realized he spent a huge amount of money on his wife's funeral and coffin. And when I asked him why, he said, I couldn't bear the thought of getting the bargain basement coffin for my wife. And then I said, well, what do you think your wife would have chosen if she had picked it out? And he laughed and said, she was a coupon clipper. There's no way she would have spent that much money on a coffin. But he had so much guilt worked up into this, he put himself in a bad position. So by planning ahead, you can help loved ones avoid sort of dealing with that. And so there are ways to actually pre-plan and prepay funerals. There's funeral insurance that you could purchase. There's all sorts of ways to sort of prepare for that piece. So I just want to mention really quickly, because I know we're getting to time and I want to give Amanda enough time to ask me the questions. We have an estate planning toolkit available on our website. It's totally free. Part 1 talks about a lot of the things I talked about today. Part 2 is state-specific information. So you'll be able to see what you need to do to validly execute a document in your state. And then part 3 is the actual documents where you can fill in the blank to get started with them. And those can be downloaded again at triagecancer.org. And then I'm going to leave this up for just a second. So if you have questions we don't get to today, please feel free to contact us through our legal and financial navigation program, which just requires that you go to our website at triagecancer.org/get-help and fill out an intake form, and then we'll set up a call with you.
Great. Thank you so much, Monica. You packed a lot into this session. Very informative, lots of questions. Of course, you're probably not surprised. So we'll try to get through as many as we can before the top of the hour. The first question, Monica, is an estate the same as a trust? That's the first question.
No. So an estate is sort of the big picture, all the things that somebody might own. A trust is a legal entity that could be part of an estate, but it is not necessarily the same thing.
Got it. The second question, Monica, for you is, an attendee wants to know, is it okay if she goes ahead and creates a will on the behalf of herself and her partner? And if she then goes to the partner and says, here it is, here's a will, I just need you to sign it. Would that be okay to do?
So wills are never joint. One person, one will. So even a married couple, people in partnerships would each need their own wills. It is helpful for people who own things jointly or have sort of combined their lives to have discussions about things. So I just want to make that point first, that you would need your two separate wills. But it would be okay if the partner read through it all and said, yeah, I agree with all of that, and then went ahead and signed it. So I know sometimes one part of a couple is more ready to estate plan than another. So that could actually be a way to make it forward, but they will have to sign it saying that that is in fact their wishes.
Got it. All right. Third question, Monica, is this person just got a trust and the trust attorney said to her, no need for a will, actually, since the trust has everything, including power of attorney. And she says, does SSDI go into the picture for owning a house?
Okay. First quick question first. SSDI is about having worked and paid into the system. It has nothing to do with assets. So that's disability insurance. Happy to answer more specifics later. Contact us through the navigation program. With respect to the trust, a will and a trust are two different things, but many times when estate planning attorneys create a trust for someone, in that process, they will also create a will and an advanced healthcare directive and a power of attorney. So I would just double check in your documents that you have something that says will on it. Last will and testament, will, something to that effect, even though, and you probably should have signed it differently than the creation of your trust. And remember, you probably paid that attorney. Feel free to go back and double check and ask.
Last quick question for you. It should be a short one, but this person wants to know is, do I need to ask a person in advance to be the power of attorney before I make him power of attorney?
You don't have to legally, but it is a good idea to make sure that that person is willing to do the job. And also think about this, right? You're in a car accident. You don't want the first time that person finding out that they're now supposed to make medical decisions for you when they get the call at 3 o'clock in the morning. So rule of thumb is anyone you're asking to play any part of your estate plan, executor, guardian, powers of attorney, to have a conversation with them before executing those documents.
Great, Monica. Well, thank you so much for doing rapid fire Q&A along with everything else. I wanted to let the folks that have been listening to Monica that just a reminder, this is all being recorded. It will be on demand for 30 days after this event on the site, the Summit event site. And to remind folks, there's a link right in the chat to help you navigate on where you want to go next. So if you have workshop 1, you'll actually be in the activity of Never Have I Ever, Breast Cancer Edition. Head over to the main stage to play a game that will surely resonate. Just click on the YSC logo at the top left of the event page to return to that main page. For the workshop 2, let's head over to the main stage for yoga and mindful self-compassion for well-being. Just click on the YSC logo at the top left of the event page to return to the main stage. Now for workshop 3, be sure to visit the exhibit hall by clicking on exhibits at the top of the Summit event site. You can claim your virtual tote bag for each of the booths and then join us back at 8 p.m. Eastern for a hangout and opportunity to chat with your peers. We will be sending out an evaluation survey, so please take the time to give us feedback. And there's also a little incentive for the folks that do enter and complete this evaluation. You'll be entered into a drawing to win a one-on-one beauty session courtesy of Lipstick Angels. And we'll also include a box of personalized, clean, non-toxic beauty products. And with that, I want to thank all of you for attending this session and a special thank you for Monica as well.